the Junior Council since 2003. In addition to our work at the bar, is an adjudicator with the RTB. Mema is the author of Landlord and Tenant, the Commercial Sector, and will be talking us through a number of pitfalls and how to avoid them, together with some practical experience in terms of antisocial behaviour, working from home, and other no pressure, other very interesting insights, no doubt, Mema, as we get to you towards the end. As always, if you have any comments, queries, or questions for our panelists as things progress, please do insert them into the chat function at the bottom of your screen, and we'll endeavour to get to as many of those as we can at the end. As you are waiting to join, you will have seen a poll. We hope to have 2 other polls as we go through, one at the end of Cullum's session and one at the end of Finian's, so please do participate in that. It's always very interesting to see how the industry views the questions posed, and we will share the results of those both afterwards and at the end of the session as well. So without further ado, Cullum, I'll hand over to yourself. Thank you very much.
Thank you, Jamie. Good morning, everyone. And as Jamie said, thank you for joining us this morning in this update in this particular area. So the residential tenancy sector continues to be a common feature in the media, and you'll have seen stories almost on a daily or weekly basis. Most recently, yesterday, the Peter McVerry Trust released their annual report in relation to homelessness. And while we had thought that the market was going to stabilise after COVID passed, unfortunately, that doesn't necessarily appear to be the case. So inflation, the cost of living crisis, and lack of stock in the market generally has resulted in ongoing issues for this particular area. Even if from a statistically point of view, if we look at some figures on a very brief basis, the number of newly registered tenancies in the first quarter of 2022 was down about 1/3 on the previous year. As Jamie mentioned, the law in this area has always been particularly complicated since it was introduced in 2004, and there's been a number of amending pieces of legislation in the intervening period. The sector was particularly busy during COVID with various pieces of emergency legislation being introduced. And more recently, again, we're seeing legislation being introduced on a reactive basis to deal with what's going on in the market. So every time I speak to clients on this, or every time I advise on this, I'm always reminded first and foremost to check the legislation and make sure that we're applying the current and correct legislation, and also to have regard to the current templates on the RTB website. And as the law changes, there's more opportunities for the landlords and tenants and agents to get the matter wrong. So it is really a case of just taking stock and making sure that, as I said, the law that you're applying on any given day is the correct law. So Sinead, we might just move on to the first slide there, if you could, please. So the first thing that I'd like to discuss today is the Residential Tenancies Deferment of Termination Dates of Certain Tenancies Act 2002. I feel like I almost need to take a glass of water before I try and read this sentence that's up in front of you. And that's the long title of the Act that came into being on the 29th of October. And there is merit in reading this Act, the long title, and understanding the purpose of the Act. So it says, an Act to make emergency provision to defer the termination dates of certain tenancies that fall or would fall during the period beginning on the day after the date of the passing of this Act and ending on 31 March, in order to mitigate the risk that persons whose tenancies would otherwise be terminated during that period would be unable to obtain alternative accommodation. To make such provision on a phased basis to enable tenancies affected to be terminated over a period of time, to assist in the managing demands on the housing service as a result of such deferred terminations, and to provide for related matters. So if we unpack that and break it down into layman's terms, effectively what the legislation or the Act is aiming to do is to slow down terminations in certain instances so that there isn't a glut of terminations, and that the tenancies who have been terminated are not left without alternative accommodation. But practically speaking, one has to question whether or not this Act is going to serve its purpose. And on the expiration of this Act on the 31st of March 2023, is the market really going to be any different in practical terms? So we might just move on to the next slide, Sinead, please. So if that's the purpose of the Act, I suppose, what does the Act mean in real terms and how is it applied? So the Act was introduced on the 29th of October, and it is temporary in nature, and it relates to the winter emergency period, as it's called. So that's the period 30 October 2022 to 31 March 2023, and that's the relevant period for the purpose of the Act. And the effect of the Act is to defer the termination of certain, but not all, tenancies that would otherwise have terminated during this winter emergency period. So effectively, the Act is saying that where a tenancy is terminated on a no-fault basis, and that termination would ordinarily fall during the winter emergency period, that termination date is deferred. And the way in which the deferred termination date is arrived at is by reference to 2 particular points. The first is the date on which the termination would have fallen in the ordinary course. And the second is the duration of the tenancy in question. And I'm going to come back to those deferred dates in a moment. This can be contrasted with the position that was introduced during the COVID legislation, where notices of termination in certain instances were paused. And in that case, what happened was that the termination date was paused, it was reactivated at a later stage, and a grace period was applied. And there was some difficulty in actually calculating what the relevant date was. Under this new regime, it appears to be somewhat more straightforward. It's important to note, however, that there are exceptions to this Act, and the first of which is that this Act does not relieve tenants from their obligations under the legislation and under their leases. Tenants can't simply cease to pay rent, for example, or breach their tenant obligations and try and rely on this Act for termination dates to be deferred. Furthermore, where a determination order has been made and the determination order provides that the tenant is to vacate on a date during the winter emergency period, that date is also deferred. So an additional provision also arises there under section 4, which is the last point on that slide, which says that where a tenant has remained in occupation for an extended period by reason of this Act, they will not by reason of this Act accrue Part 4 rights. So Sinead, I might just move on to the next slide there, which deals with what are the deferred dates. So as I said, at a very high level, the Act says that if a tenancy termination on a no-fault basis is to fall during the winter emergency period, it's deferred. And you'll see there across the top is the first consideration. When was the termination in question supposed to fall in the ordinary course? And down along the left-hand side, you can see the duration of the tenancy. And it's the sum of those two things then that give you the deferred termination date, which as you see are staggered. And again, the reason for the staggering of termination dates is to make sure that there isn't a glut of terminations. So just moving on to the next slide, Sinead, where I've just given two examples, practical examples of how this is going to work in practice. So the first example here, we have a tenant is in arrears of rent. The landlord issues a 28-day termination notice on 1 November. So it's after the introduction of the Act. And in the ordinary course, that termination date will expire on the 29th of November, which is during the winter emergency period. However, because the termination notice here is based on fault or the breach of the arrears of rent, it's business as usual, and the landlord can proceed to look to have the tenant removed from the property. On the flip side, we have a no-fault example there at number 2, where the landlord intends to sell the property. The tenant has been in occupation for 2 years, and on the 1st of August, the landlord serves a 180-day termination notice, which in the ordinary course would expire on the 27th of January 2023. Again, that falls within the winter emergency period, and as a result, you have to have regard to the table we just discussed, and you get a new deferred termination date of 15 April 2023. So Sinead, you might just take me on to the next slide there, please, which leads us nicely into arrears of rent, and this being one of the provisions that is not captured by the Act, and tenants aren't saved by the Act. So the rent arrears procedure at the moment is governed by the Residential Tenancies and Valuation Act 2020, and it's quite procedural and it's quite involved on the part of the RTB. Originally under the 2004 Act, when a tenant was in arrears of rent, you served a warning letter followed by a termination notice, and that was effectively it. During the COVID era, we then saw a 10-step plan, which had a massive amount of involvement from the RTB, and we now have a slightly pared back version of that. You might just take me on to the next slide, Sinead, please. So at a very high level, what you have is a 6-step process in the rent arrears procedure, and just taking you through that step by step very quickly. The first is that the landlord will issue the warning notice, which must provide a minimum of 28 days for the tenant to pay the rent arrears. That notice must set out clearly the amount of arrears and must also state that in the event that it's not complied with, a termination notice may follow. Interestingly, while the legislation has been updated over the last number of years, the service provisions have not. So service of a warning notice and a notice of termination must be in accordance with the original Act, and that does not include text messages or emails. Step number 2 there, you'll see is the landlord must send a copy of the warning notice to the RTB. And this is where we start to see the involvement of the RTB in this rent arrears process. And what's critical to understand under section 2, and indeed all of these steps, is that if any of these steps are not complied with, it will result in a notice of termination failing. And what's important under step 2 is that the 28-day period will start to run from the latter of the date on which the warning notice is received by the tenant or the RTB, as the case may be. On receipt of the warning notice, the RTB then under step 3 will write to each of the landlord and the tenant. Insofar as the landlord is concerned, the RTB will notify the landlord of how the procedure is run. And on the tenant side, the RTB will notify the tenant of the assistance that's available in terms of MABs and citizens information, and try and assist the tenant in getting that help from MABs. If that's unsuccessful and matters haven't been resolved and the debt is outstanding, We then move to step 4, which is the notice of termination itself. And the notice here must provide for 28 days notice. And again, it must be served on the tenant in the prescribed form. And a copy under section 5 must also be sent to the RTB again, so you see the involvement there. And this final step in the process, insofar as the notice of termination is involved, is that the RTB then writes to the tenant and effectively notifies the tenant of the option available to them to challenge the notice of termination. So you'll see it's quite an involved process. And while it's relatively straightforward, as I said, failure to comply with any one of the steps will render your notice invalid. So it is a case of just sitting down and making sure you're ticking all of the boxes as you go along. Moving on to the next slide, Sinead, please. So in terms of a tenant's obligations, while this rent arrears procedure is going on, the tenant is still obliged under the legislation to pay the rent. And while that is the position in law, in practice, I think that we'll often find that that's not the case. Typically speaking, where a warning notice followed by a termination of notice is issued for arrears of rent, the tenant has already stopped paying rent either in full or in part. And typically the tenant will continue to do so for so long as the dispute is ongoing, but the landlord is entitled to the rent. And it's also interesting to note that even if the tenant has vacated, it's still available, and there's arrears of rent, it is still available to the landlord to pursue those arrears. And that's, I suppose, a commercial question for the landlord. Oftentimes the landlord will be happy simply to get back the property and do whatever is required to get it back on the market, and may take a view that actually it's not worth the cost, time and effort in chasing the arrears, depending on the level of them. However, again, if there's significant arrears here, it may be worthwhile pursuing. Just on to the next slide there, Sinead, please. So just by way of summation, I suppose, on the takeaways from the new Act and just the rent arrears procedure, tenants are still obliged to honour their obligations, which includes the payment of rent, so rent continues to fall due. And you should make sure that you're applying the correct procedure at any given time. Just as a way of general summary of what we're seeing in the RTB at the moment is we are aware of delays, that the RTB has, as we understand it, disabled the web chat function at the moment, and is requesting that parties who are engaging with the RTB don't send multiple follow-up emails looking for a reply because they're simply overwhelmed. And I do wonder, is part of that difficulty as a result of their increased involvement in the rent arrears procedure and indeed other procedures under the legislation. The RTB has also moved to, in relation to the dispute resolution mechanism, that a telephone adjudication or mediation is now the default position rather than adjudication. And that's going to come up in the poll in just a moment. And finally, just you should be aware that the RTB has recently published a template lease that they are, I suppose they're not necessarily recommending, but it is on their website. And it may be that you want to consider your own template leases that you have to make sure that they're in full compliance with the current legislation and the approach that's being adopted by the RTB. So I'm going to pass you over to Finian, who's going to deal with some more recent developments over the last number of months. And I think Sinead is going to pop a poll up on the screen as well, and I'll take some questions at the end. Thank you.
Thanks, Colin. Sinead, if we could just move on to the next slide. Thanks. And so I'm going to take a look at 3 aspects that have been introduced by the Residential Tenancies Amendment Act 2021. They are the tenancies of unlimited duration, the notice periods that are required to be provided to tenants when terminating a lease, and also the requirement to offer property back to a tenant following termination in certain circumstances. And just move on to the next slide. Thanks. So tenancies of unlimited duration were introduced on the 11th of June 2022, and it is said that they will have implications for both landlords and tenants, with the government's aim of such tenancies being one of the tools to create a sustainable housing system in Ireland. In that regard, at the passing of the legislation in December 2021, the government press release stated that tenancies of unlimited duration are a key reform committed to under the Housing for All, which is the government's housing to create a sustainable housing system. The Minister for Housing at the time commented that the legislation respects the constitutionally protected property rights of landlords and aims to safeguard continued investment in the sector by existing and new landlords to deliver the requisite supply of high quality rental accommodation. But I suppose the real issue for landlords is what exactly do tenancies of unlimited duration mean for them? The big change that landlords will find is that whereas once a Part 4 tenancy came into being, it previously rolled on 6-year cycles, meaning that the landlord could terminate the tenancy without reason prior to the end of each 6-year cycle by serving a notice of termination. A part for tenancy will now come into being when, a part for tenancy will now become unlimited duration when it comes into being, and it comes into being after tenancy has existed for 6 months. So really the change that landlords are going to see is that there's no longer any termination of a tenancy after 6 years. In addition to that, landlords should be aware that a tenancy that existed prior to the 11th of June 2022 will automatically become a tenancy of unlimited duration at the end of its current 6-year cycle, unless the notice of termination is served prior to the end of that cycle. So if we just move on to the next slide. So it has been said that the introduction of tenancies of unlimited duration have created some unintended consequences, and that it has resulted in a wave of panic amongst landlords, as there has been widespread reporting of elevated levels of landlords serving notice of termination. And while some of this increase in termination notices being served may be due to the moratorium in serving such notices that was in place throughout the pandemic, it has been reported that much of the increase arises from a misapprehension amongst landlords that they will be unable to remove a tenant once their tenancy becomes one of unlimited duration. And in this regard, we've seen a 58% increase in the number of notices of termination being served in the first 6 months this year when compared to the previous 6 months, with some 55% of those notices of termination being for the purposes of sale. In total, I think it was 2,913 notices of termination were served between January and mid-August this year. So it seems that landlords are taking the opportunity to terminate tenancies and exit the sector prior to tenancies of unlimited duration taking effect on their property, which is having a negative effect on the government's Housing for All scheme, and in fact is really having the opposite effect to the objective of that scheme, which is to preserve and sustain the rental sector. It's kind of showing that landlords do play a pivotal role in the provision of rental accommodation, which cannot be met by the government. And in that regard, Focus Ireland have even stated and urged the government to introduce a tax relief for landlords who allow tenants to stay for a specific length of time. So if we could move on to the next slide. So despite the number of landlords leaving, in reality, the legislation does not actually prohibit a landlord terminating a tenancy at all. And the same 6 reasons that always were there for terminating a tenancy remain, and they are where the landlord requires the property for himself or a family member, where they intend to sell the property within the next 9 months. If there's a change of use of the property, if they plan to substantially refurbish it, or if the tenant is in a breach of tenancy conditions, or the property is no longer suited to the tenant's needs. So if we could just move on to the next slide. So the real change that landlords will actually see is that there has been a change in the notice periods that are required to be provided to a tenant when terminating a tenancy. And in that regard, they now range from 90 days where a tenancy has existed for less than 6 months, up to 224 days where a tenancy has existed for in excess of 8 years. And landlords should also be aware that they may need to have regard to any fixed term tenancy that is in place. And in addition to the 6 reasons for termination that I previously mentioned, a landlord may also terminate a tenancy owing to rent arrears, which has been covered by column. And just to mention that those notice periods came into effect on the 6th of July 2022. So if we could move on to the next slide. So then just finally really to mention that landlords should be aware that there can be a requirement to offer a property back to a tenant. And that occurs where a tenancy has ended for certain reasons and the property then becomes available to rent again. In such circumstances, the landlord must offer the property back to the tenant within 12 months of the expiry of the notice period. So if the property becomes available within that 12 months, they must offer the property back. And they only need to do so where they had terminated the tenancy because they planned to sell the property within 9 months and that did not occur. that they needed the property for their own or family use and it has become available again, that they planned to change the use of the property and that did not occur, or that they refurbished the property substantially and it is available again. One final thing that landlords should be aware of is that where there is a requirement to offer the property back to the tenant, there is now a requirement on the landlord to use reasonable efforts to obtain the contact details of the tenant and offer the property to them. This includes a requirement to contact the RTB and request those contact details. So this is a kind of a change where previously it was up to a tenant to ensure that the landlord had their contact details. It is now up to the landlord to actively obtain the contact details where possible. And once the property is offered back to the tenant, they have 7 days to accept or reject that offer. So if we could just move on to the next slide. So just the key takeaways to note are that the legislation has introduced tenancies of unlimited duration. Such tenancies really have not deprived landlords from actually terminating tenancies for the 6 stated reasons that I referred to. And what has really changed is that the notice periods that landlords must provide a tenant when terminating a tenancy have increased. So I think we then just have a poll.
Thanks, Finian. Is that over to you now, Mema?
Oh, thanks very much, Jamie. Okay, my name is Mema Byrne. I'm a practicing barrister. I'm also an adjudicator and mediator with the Residential Tenancies Board. I've been asked this morning just to speak for a few minutes, so it's going to be very quick, about issues that arise in adjudications in the RTB. I am going to focus on antisocial behaviour, working from home, and the corrective notice procedure. While antisocial behaviour, that's the next slide there, Sinead, is not the most common reason that a tenancy is terminated in the RTB, it is certainly one of the most difficult cases to run. And people have difficulty in ascertaining what type of evidence that they should prepare for such a case. So just to identify for people that there are in fact 2 types of antisocial behaviour. The first 2 are described in section 17A and B of the Act. And when you read them, you'll see that they really constitute what we would say as very serious antisocial behaviour. And the first one there involves the commission of an offence. The second one there you'll see is behaviour that could cause fear, danger, injury, damage or loss to any person. And it gives examples then of what that may be, including violence, intimidation, coercion, harassment. So what you might be envisaging there perhaps is, drug dealing in the stairwells or that type of behaviour where an offence may not have actually occurred, but it may intimidate the other residents there. So the importance of knowing the difference between this and the next type of antisocial behaviour is if it is this type of antisocial behaviour, a 7-day notice of termination may issue. Whereas if it is the next type, which I'm going to show you on the next slide, then it is still a 28-day notice of termination. So you need to be really certain that, first of all, the behaviour fits within either of these categories, and that you have the evidence to bring it home if you're going to only give 7 days notice. What I want to bring to people's attention there is another reason why you can give a 7-day notice, and that is where there's behaviour or at the dwelling that is threatening the fabric of the dwelling or the property containing the dwelling. So that is a separate reason to terminate a tenancy for 7 days, and it doesn't come within the definition of antisocial, and it's much more useful to use if you're looking for a 7-day termination. Sinead, maybe the next slide, please. So you'll see that the second type of antisocial behaviour is, and this is the one that comes up far more regularly, is persistent behaviour. So what you see here is generally non-stop partying, people pouring out at the front of the house with beer cans several nights a week, rubbish accumulating in the back garden, attracting rats. So it's ongoing behaviour. And this requires a 28-day notice, and that's the difference. So if we could have a look at the next slide, please, there. What I want to have a look at is just the type of evidence that you would be looking for in the case of the more serious antisocial behaviour under sections A and B. So if you're alleging that there has been an offence, has there been a report to Garda Síochána? Has the tenant been prosecuted? Has there been a conviction? So you often see people saying it is an offence, but there's no evidence that there has been an offence. So be there where the behaviour is, let's say, causing intimidation or causing fear or danger, is a much easier threshold in terms of evidence, but it usually requires first-hand evidence from a person who's able to say, I witnessed the behaviour, I was afraid, I felt intimidated by the behaviour, and that's the type of evidence that can bring a case home under section 17B. Sinead, if we could have a look at the next slide. There. Now the persistent behaviour, it really requires, I think, in my view, the keeping of a notebook to record the frequency of the behaviour, and then preferably photographs or sometimes video recordings of that behaviour. So what a landlord has to be very alive to is, and what we see sometimes in the RTB is instances of racism occurring. So a family or a person will move into a neighbourhood, and then there will be a series of complaints to the landlord or the landlord's agent, and they don't let up. And then the landlord is under the impression that they need to take action against the tenant without actually doing any investigation as to whether there has been persistent behaviour that prevents other people from interfering with their peaceful occupation of the premises. So landlords need to be very alive to that, and if they're going to take action on foot of the complaints that they're getting, they need to assess that evidence before they take action on foot of those complaints. Okay, the next issue that I'm going to look at is working from home. If we could have a look at the next slide, please, Sinead. And you'll see that under the Act doesn't apply to a dwelling that is used partly for the carrying on of a business. And then it qualifies that such that the tenancy could ground an application for a new tenancy under the 1980 Act. And when you look at the 1980 Act, in order to qualify to have a tenancy renewed as a business tenant, you must be carrying out a business for 5 years at the premises, but it has to be bona fide as a business. So you're not allowed to move in as a residential tenant, start using the premises for a commercial purpose, and then try claim a new commercial tenancy under the 1980 Act, because it's not bona fide. But what landlords need to be very alive to now is that tenants may be requesting, so that they're not in breach of their tenancy agreement, for consent from the landlord to use the premises partly for a business. And if you do give that consent, you may be opening yourselves up to a later claim for a renewed tenancy under the 1980 Act. So that's something that everyone should be alive to. If we could have a look at the next slide. Sinead, I'm just going to bring people's attention to these two provisions. The first one is the slip rule that has been there for longer than the second new introduction, which is to issue a remedial notice. So both sections, and I'm going to have a look at them separately, allow for some type of clawback if there has been an error in the service of the notice or in the notice of termination itself. So when the Act started, if you made a mistake in relation to the service of the notice or in the notice itself, you would have your notice deemed invalid when you came to your hearing at the RTB, and you would have to start again. Now we have the slip rule, and that's under section 64A. So it is the first port of call if you do notice that there has been an error in either the service or in the notice itself. And that applies where the error does not in itself render the notice of termination invalid. If the landlord can convince the tribunal that the slip or omission doesn't prejudice in a material respect the notice of termination, and that otherwise the notice of termination is in compliance with the provisions of the Act. This really, in my view, only allows for one mistake, because the section itself says, and it's otherwise in compliance with the Act. So I have seen people who say, look, I put the date wrong on it, on the date that I served it, and I served it on the wrong number of house, but actually I found out later that they did receive it. I don't think it can apply there, because under B you'll see that it has to be otherwise in compliance with the Act. But it does allow certain mishaps to be remedied. So for example, and I'm loath to give an example because each case will depend on whether it hasn't prejudiced the tenant in a material respect, depending on their circumstances. But for example, if the letter was addressed to the wrong numbered house, but the tenant then phoned the landlord and informed the landlord that they'd received it because the neighbour had dropped it in, that's an instance where you may say, look, it wasn't addressed to the tenant at the correct address, but nobody has been prejudiced by this. And under the slip rule, I'm going to allow the notice of termination be deemed valid. So the next slide, please, Sinead, is for a more serious situation. But again, I think the RTB have recognised that due to the much longer notice periods that tenants are now entitled to, that sometimes despite the notice of termination actually being invalid, that the circumstances are such that the defect doesn't prejudice in a material respect the original notice, and the original notice is otherwise in compliance with the Act. And what this section does is it allows the adjudicator to make an order that a remedial notice be served, giving a minimum of 28 days notice to the tenant. If the tenant was entitled to other notice to terminate the tenancy, they're entitled to any other notice period that they were entitled to be added to that 28 days. So it's not a way of reducing the amount of notice that a tenant is entitled to. So they're very, very important sections, and I have come across them being used on a reasonably regular basis to save an application on the part of a landlord where there has been an error, and everyone should be aware of them, because you may have to plead them even at the case in case the adjudicator picks up that there was an error that nobody saw prior to the hearing. Jamie, I'm going to hand back to you now. I hope I've stayed within my time, and thank you very much.
Thanks, Mama. That was that. Excellent level of detail there. Thank you very much. Just waiting for my camera to flick on. There it is. Thanks, everybody. So we have a fantastic number of queries and comments and questions in, and we'll try to get to some of those quickly. But just in case it provokes any further comments or questions, perhaps Sinead, we might quickly run through the results of the 3 quick polls if we can. If we can pull up the first poll first. So, is government housing policy disproportionately relying on the private sector to address the housing crisis? And 88% yes there, which I think is not altogether surprising, I think, given recent conversations and perhaps lack of government build at the moment. Second one, please, Sinead. So poll 2, is telephone mediation preferable to in-person virtual adjudication? 60-40, I have to say, I personally was expecting a much higher no split there, but I think we have some questions in relation to this process as well, which I think when people maybe think about it a little bit more, that might be, and not that I'm trying to skew the results, that might alter those results a little bit, but interestingly, that's so finely balanced. And then finally, Sinead, the third one, please. Couldn't get any more finely balanced. The tenancies of unlimited duration, are they going to make a difference to how institutional landlords approach their operations? 50-50 right down the middle. I think certainly if anybody has any comments they want to put in there, I would be interested to hear how those on the no side feel that that's going to materialize itself, given the, I suppose, the grounds which the guys ran through, pursuant to which the tenancies can still be terminated. Okay, so Finney and Cullum, thanks very much for that. I might just run through some of the questions, having had a look at them as they've been coming in. Mema, I might go to you first. There's about 7 questions I would suspect here, all interrelated to antisocial behaviour.
Okay. Hopefully I can answer them, Jamie.
And I think what we were saying beforehand was that in answering any questions along these lines, given the amount of legislative changes, just everyone's starting point will be the legislation, and nobody has the legislation in front of them. So this is not legal advice. But if anyone wants to follow up with us, we're happy to do so afterwards. But just on the antisocial behaviour and trying to pull a number of these threads together, like in the absence of someone saying that something wrong was done, I suppose what's the next best level of proof? Then linked to that, do you have to have a Garda report evidencing it?
My advice really is to try avoid going under Section 17A unless the person has been convicted. In circumstances where that is the one that you're least likely to bring home.
Okay.
Even where there has been, if it is a case that somebody is behaving in a way that, for example, is going to negative the insurance in respect to the dwelling, it would be far preferable to go under the section where you say that the tenant is materially, I don't know what the language of the section is, but materially putting the premises in danger. So they're acting in a way that's threatening to the fabric of the dwelling. So that is a much more useful section, and that's why I brought it to people's attention than to rely on Section 17A. Jamie, I've gone off point a little bit. You're saying we need a Garda report. A Garda report in itself doesn't prove that somebody has engaged in an offence. It means that somebody has made a complaint to the guards. So where these applications are very hotly contested, you are innocent until proven guilty in this state, thank God. So you can imagine where they're hotly contested, how hard that will be to bring home. I have had cases, though, where people have been found guilty of having firearms on the premises. So obviously they succeed, but that's the level really that you're looking at. So if the person is behaving in a menacing way, Section 17B is the section that should be relied on, really. And in terms of evidence for that, I think one of your questions was if somebody didn't have someone willing to give evidence. Is that the case?
Correct.
And again, that's a common thing that happens because people are intimidated sometimes by these tenants. And in those circumstances, usually what you would be looking for is a notebook kept by somebody that's corroborated maybe by another tenant on the other side, maybe, coupled with perhaps video evidence or audio recording. So I've often listened to recordings in the RTBs of parties going all night. Now, again, I have had cases before me where somebody complained about antisocial behaviour because somebody threw one party a year over a long weekend. That's not going to succeed. It's not persistent, and it's really not a nuisance. They're the vagaries of not living in a detached house down the country. But what you're looking for is enough proof to show the adjudicator that what you're saying actually occurred. And people, very often we would see diaries from a number of neighbours coupled with an audio recording of all night partying, and that has certainly been accepted.
Okay, thanks for that. And we're given the time, we're not going to get them all today, but we have a number of questions around the legality of actually taking those video or audio recordings from a privacy perspective. But Finian, perhaps linked to the privacy point, we have another question in relation to, given that the obligations have been inverted, so it's just that the landlord has to take active steps to try and get details from the RTB. Are there any GDPR/privacy issues in the RTB giving out that information?
So when the RTB contacts the tenant, they ask for consent to provide the contact details to the landlord. So I think under GDPR, they'd be able to provide those details and provided consent was given.
Okay, thanks, Vinny. I think Column's pulling together 2 or 3 questions, and indeed a question I have myself was in circumstances where the landlord has vacated the property pursuant to a number of grounds, but I think the question here is looking to sell the property and it hasn't sold, and the property has to be re-put back to the tenants. At what rental level is it being put back to the tenant at?
So I think the first thing to note there is, Jamie, is there is, in my view, and I think myself and Mema have discussed this previously, she concurs with me, there is an ability to serve multiple termination notices on various different grounds to tenants. So if a landlord is selling and also intends to refurbish the property, there's no reason, in my view, provided the dates line up, that you wouldn't serve 2 termination notices. And if you then have to offer back the property, and the question is on what basis do you have to offer it back? If you have then served a notice of termination on the grounds of sale and on the grounds of substantial refurbishment, you should be able to rely on the substantial refurbishment or the substantial change to avoid the rent caps or to circumvent them. I think if you haven't done that and you simply say you're going to sell the property and then you put the property doesn't sell and you have to offer it back, I think the terms of the expired lease is what you'd have to go under. And you may be able to carry out a rent review in the ordinary course, depending on when the last rent review was carried out. But I don't think you can simply just knock up the rent because the sale of the property hasn't gone through and you've had to put it back to the tenant.
Okay, thank you. Then so a number of comments. If the RTB are under-resourced and their new site is not fit for purpose, and we are held accountable to adhere to their rules and pay their fees, who is accountable in the RTB? I won't ask you to jump in on that one there, just sharing it for everyone's benefit. Mema, are there any examples, and sorry, if they're not, don't worry, are there any examples of where an error would materially prejudice the tenants? It's an error in the face of the notice.
Yeah, well, each tenant obviously is different. So what may materially prejudice one may not another. For example, somebody's level of understanding or something like that. They may not understand an error in the same way that somebody else is. But like a material prejudice to the tenant, for example, would be not informing the tenant that they had a right to reoccupy the premises. And then that set of circumstances came up, for example. Or something that would materially prejudice them is that they didn't receive the notice at all. So sometimes people would say, well, I sent it to their email. Other times they sent it to the email and the tenant phones the landlord and says, I just got your notice of termination, and emails them back, let's say. There we know that the tenant received the notice of termination. So the question is, are they materially prejudiced by the fact that the act was not strictly complied with? In another instance, it's sent to a defunct email, and therefore it did materially prejudice. And the tenant comes in and the landlord says, I emailed it to them. And you say, well, you're not allowed to do that under the act. And they say, well, they should have got it anyway. And the tenant says, no, I left that employment and I don't use that email anymore. How would I have got it? So there's an example of the exact same situation prejudicing one tenant, but not prejudicing another.
Great, thanks, Nana. Conscious of time, I'm also conscious that we have 18 unanswered questions. We're not going to get to them all, but maybe just two more if I can. Whoever wants to take this one can jump in. Are both parties, landlord and tenant, responsible for their own costs when a case is referred to mediation?
So I might take that, Jamie, if that's okay. So the mediation cost, it's a nominal fee, basically. I think it's about €25 what you have to pay when you lodge your dispute. And typically speaking, the mediator, sorry, the adjudicator, the adjudication is €25, and the adjudicator will not award costs, as I've never actually really see it happen. There is an ability at the adjudication and at the tribunal stage to award costs, but I've never actually seen it happen in practice. And as I understand it, the telephone mediation process is a free process that the parties can get involved in. And that's part of the reason that the RTB is kind of advocating it. One, because it's free. And two, because they say it's going to be quicker than the adjudication process. Because in the view of the RTB, they can get the parties to mediation on the calls rather than trying to set up meetings, be they virtual or in person. But as I said, my preference, and again, I think having discussed it with Memo over a cup of coffee, is just practically speaking, where you have two parties on two ends of a telephone call and a mediator, you don't get the same buy-in as you do with an in-person or a Zoom adjudication. And for those reasons, our preference is that you would go ahead with the adjudication and suffer the nominal €25 fee that's involved in it.
Okay, thanks. And then perhaps one last one, and it's for you, Colm, because the person who's asked the question said for Colm. Where a deferred termination date applies, is a landlord obliged to notify the RTB?
So there's nothing that I've seen in the legislation, and the new act is very short. You'd read it in a couple of minutes, and helpfully, unlike the previous temporary legislation, it doesn't make references to sub-paragraphs and previous bits and pieces. So I don't see that there's an obligation to notify the RTB of the deferred termination date. But practically speaking, if you served a termination notice on a tenant, and there's now going to be a deferred termination date, I think as a matter of course, you probably would be writing to your tenant and saying, I served my termination notice on whatever date, you're supposed to leave on X date, but as a result of the recent legislation, that's now pushed out to Y. Mehmet, do you have a view on that, just practically speaking?
Well, I think the question, Jamie, was in relation to the obligation to notify the RTB, right. Was it? The obligation to notify the RTB arises at the time of the service of the warning letter and the notice of termination. So once that has been done, your statutory obligation has been completed. And the fact that the tenant is getting some extra time to stay over, like Colm said, in order to make sure the tenant doesn't come back and say that you illegally evicted them during an eviction freeze, it would be prudent to write them a letter saying you were supposed to get out in the blank day of blank, but due to the suspension of evictions during this time, you're now entitled to stay till the blank day of blank. And that way nobody can say you forced them out the door. But there wouldn't be, in my view, and I haven't seen the legislation, I have to say that in front of me, but there wouldn't be, in my view, a renewed obligation to re-inform the RTB of the new date. Your obligation arose at the service of those notice times.
Okay. Okay, Colm, Mema, Finian, thank you very much for your time. Very informative, an awful lot there. Thank you also to everybody who tuned in. We will be circulating afterwards a survey. Please do take the time to provide any feedback that you like. It is very valuable. It is also an opportunity to give us some information about any further things you'd like us to cover. Very conscious that we haven't got to the now 19 questions that have come in. If anybody would like to follow up with us, please do drop us an email. And finally, to answer one last question, which did come in, yes, the recording of this will be available. So that's an easy one, which I'm glad to take. So thank you very much, everybody, and have a great day.
Thanks very much.
Jamie, bye.